How does a financial power of attorney work with a trust? Have you ever wondered how a financial power of attorney interacts with a trust? Understanding this relationship can help you manage your estate planning effectively. Let's break it down. A financial power of attorney is a legal document that allows someone to act on your behalf regarding financial matters. This person is often referred to as an agent or attorney, in fact. They can handle tasks like managing bank accounts, paying bills, and filing taxes if you are unable to do so. The authority given to the agent can be broad or limited, depending on how the document is written. On the other hand, a trust is a legal arrangement that holds and manages assets for the benefit of designated beneficiaries. The trustee is responsible for managing these assets according to the terms of the trust agreement. Importantly, the trustee's authority is limited to the assets owned by the trust. Now, how do these two tools work together? First, it is essential to know that a financial power of attorney does not automatically give the agent control over trust assets. The trustee manages those assets, not the agent. This means if you have a trust, your agent cannot access or manage those trust assets unless the financial power of attorney document specifically grants that authority. If you want your agent to handle trust assets, the financial power of attorney must clearly state this authority. However, even with this authorization, some financial institutions or trustees may not recognize the agent's authority over trust assets. This can lead to complications. It is often simpler to keep the roles separate. Let the trustee manage the trust assets while the agent handles your personal financial matters and assets outside the trust. This separation helps avoid confusion and potential legal disputes. The agent can manage personal assets not transferred into the trust, such as bank accounts, retirement accounts, and personal property. Remember, trust assets must be formally transferred into the trust's name for the trustee to manage them. Anything not transferred remains outside the trust and can be handled by the agent. Even if you have a living trust, having a financial power of attorney is still important. The agent can manage your personal financial matters that the trust does not cover. This arrangement ensures that both your trust property and your personal affairs are managed effectively. From an estate planning perspective, keeping these roles distinct helps ensure clarity and proper management of your assets. It reduces the risk of conflicts and helps ensure your wishes are followed during your lifetime and after. It is wise to work with an attorney to draft both documents carefully, clearly defining the authority of both the agent and the trustee.